Hi guys, and welcome to my channel. My name is Diana Romanovska and I am a certified family law specialist practicing family law in the Bay Area. Today I would like to talk about what happens when everything didn't work out. The hearings, negotiations, and now you and your spouse are forced to go to trial. What to expect, what to file, what to do. If you don't have an attorney, I suggest to consult an attorney. This is only an informational video describing general principles about how to get to trial. For example, in San Francisco, first there is a hearing, and then if parties have so many issues to settle that the judge is not able to address in a hearing, which is 20-minute calendar, typically type of hearing, then the judge first schedules a date for mandatory settlement conference. Mandatory settlement conference is approximately, and again, this is just in San Francisco. In Marin County, for example, it's called different. It's called bench bar, and it's longer than 3 hours. In San Francisco, it's typically 9 to 12, and another lawyer volunteering to help settling. In Marin, it could be all day long. In Alameda, it could be another judge at the settlement conference. In San Francisco, if mandatory settlement conference doesn't lead to successful settlement, then the judge orders another so-called judicial settlement conference, meaning where a different judge, not the judge who decides about the particular case, but a different judge helps to settle the case, and it's again typically 3 hours. And I noticed that the settlements that are longer, for example in Marin, they tend to be more successful. And I like the fact that in Marin there are more volunteers. Sometimes there are 3 attorneys who help to settle, 2 or 3. In San Francisco it's 1, in Alameda it's 1, and in San Mateo it's typically the judge who decides about the case. That judge talks to the lawyers in the chambers. So if everything failed and now the trial is the only option, what happens? Parties could, if they have a new judge assigned, they can, for example, if they know that this judge is famous for some, they want to exclude the judge for whatever reason, then CCP code section 170.6, and you gotta read it to make sure all timely notices apply, and you have 10 days from the time the judge was assigned for all purposes that this judge can be disqualified without any particular reason. So the parties don't have to state a reason, and it will be this motion will be granted if it's timely. If there is a reason, for example, the judge was related or somehow had contact with another party, or the judge was for some reason somehow connected to this personally, then the correct code section that describes how to do it is CCP 170.1. And when I say CCP, it's Civil Code of Procedure. Number 3, although family courts are a little bit looser with evidentiary rules, they still apply. The due process, the hearsay rules, evidence code apply in family court. And although in number 4, and I have 10 numbers that I would like to describe. Number 4, family courts are more informal than in civil court. For example, the judge can invite both attorneys to speak in chambers and encourage to settle and talk about the case, and maybe give a little bit a hint, not necessarily a hint, but sometimes an obvious hint, how the judge would tend to decide to make sure that both parties are incentivized to settle. The judge might propose a settlement in the middle of a trial. It happened to me when we were sitting in the trial, we were arguing, the judge was asking questions, I was cross-examining. The judge stopped the trial and said, actually, I would like you to step outside because it sounds like you could all reach an agreement. If you don't, come back in 20 minutes and we continue the trial, and we reach an agreement. So those informal rules are very common in family court. Number 5, emotionality. Trials are very exhausting, not only for the parties involved, but also for attorneys. There is so much preparation goes into it. Preparation of exhibits, cross-examination questions, witness examination questions, sending subpoenas out, doing discovery, doing depositions prior to trial, because how do I know what the other party is going to say in trial if I didn't depose them before? And you will be surprised how much we can find out by deposing the other side. And it also helped to impeach, meaning to prove that the other side was not telling the truth. When we say at the deposition, you said one thing, but now you're saying another thing. So credibility is a huge factor for trials. When someone is not telling the truth and they're testifying under penalty of perjury, then of course their ability to quote win or be credible and basically get what they desire is going to be diminished if they're not credible. So number 6, no juries. In family court, there is one judge, no jury. Number 7, witnesses who may testify can be excluded. So the judge doesn't want to have witnesses hear other people's testimony before the witness himself or herself testifies. Number 8, pretrial motions. So before the actual date of trial, both parties have to prepare trial briefs, witness list, exhibit list, potentially bring sealed deposition envelope to the trial. And all of that has to be looked at when to submit that in terms of timeline into local rules of each county. Some counties have it 5 court days, some counties have it 2 court days. So it's very important to read local rules before going to trial. Number 9, motions to eliminate, meaning some evidence can be precluded. For example, if I'm deposing opposing side and I find out they have a recording in the bedroom without permission by another side that they would like to introduce in trial, and I know it's in violation of a penal code, and I would immediately file, and it has to be done prior to trial, a motion to eliminate and ask the court to exclude that particular exhibit, or if it violates some other rules, hearsay or whatever evidentiary rule or any other rule violates, it has to be dealt with prior to trial. Sometimes if I'm not aware of particular evidence, then I object in the trial as we go. So that can be also done during the trial. And you hear a lot in movies, I object. And so when the lawyer says I object, everyone stops and the judge stops talking, especially the testifying person, until the judge rules and says overruled or granted. And then the other person can testify if the objection is overruled. And finally, settlement. At the time when the trial is happening and the judge says, stop, go out, settle, I can hear that you are all close and this is what I suggest. And the judge has to ensure that there is no coercion and everyone is settling voluntarily. And the settlement can be spoken on the record during the trial time, and it becomes a binding agreement, which means if someone violates it, the other person has remedy based on CCP Code Section 664.6 and ask sanctions for violating such an agreement. Anyway, I hope that was helpful and I will see you soon. If you liked it, please click like and subscribe. I will see you later. Bye.